Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello beautiful people, welcome back to our channel. Many followers of Fubara and many lovers of River State have been observing quietly to see what will eventually become of Fubara within the next 3-4 months. Remember, there's been a case of state of emergency and sole administrator right now sitting in, and there have been pressure from Rivers women, supporters of Fubara, lawyers, well-meaning Nigerians, that this is so undemocratic, a state of emergency being declared and suspending democratic institutions in River State. Well, Bola Tinubu have decided to do what he feels is the need for. And for some of us who have been thinking Fubara needs to port to APC, and Fubara is making moves to port to APC, all of this you would now deduce. What is the fate of Fubara, fate of River State and democratic institutions in Nigeria? Well, before we go to the newspaper, kindly subscribe to our channel. Now, according to the news, the federal government has formally tabled before the Supreme Court its reasons for imposing a state of emergency on River State, citing collapse of governance and attacks on critical national economic infrastructure as key factors. Already as we speak, Bola Tinubu have gone to Supreme Court on this matter. Let's go to the news. Now, it says it has no choice but to intervene. The government laid its position bare before the Apex Court some few hours ago in response to a suit filed by 11 states mostly controlled by the opposition People's Democratic Party, PDP. The states are Adamawa, Akwa Ibom, Bauchi, Bayelsa, Delta, Enugu, Osun, Oyo, Plateau, Taraba, and Zamfara. Excuse me. The plaintiff alleged that the federal government erred in law by imposing emergency rule on River State. However, the federal government is disputing the plaintiff's claim. Now, that's the plaintiff's claim. Now, in an affidavit by a special assistant to the president and the Federal Ministry of Justice, Mr. Taye Hossan Oluyede, the federal government alleged a very serious political crisis in River State, which culminated in the declaration of a state of emergency by President Ahmed Tinubu on March 15, 2025. It said critical economic assets of the state, including oil pipelines, became targets of vandalization, while militants openly threatened fire and brimstone against those who they perceived as enemies of the governor. With the governor not doing anything besides, the federal government said the state's crisis reached a point where the suspended governor, Siminalayi Fubara, demolished the state of assembly, the State House of Assembly, that's their complex. It said the breakdown of law in the state was such that only 4 members of the State Assembly were sitting in Fubara's office. It said that 27 other lawmakers were deprived the constitutional right to make laws for the state. It said that the governor and the lawmakers were trying to outdo one another in a series of suits on the political logjam in the state. The federal government said the governor was not able to present any appropriation bill to the House to be passed to access funds to the state. It also confirmed classified security reports that Fubara demolished State House of Assembly complex. Oluyede in the affidavit said, "I am a special assistant to President Bola Ahmed Tinubu, GCFR. By reason of that, I have been working in close contact with the Honorable Attorney General of the Federation. The first defendant in the case, further by reason of the same position, I know the fact of this case and I have the authority of the President and Chief Akin Olujimi, CON, SAN, counsel to the first defendant, to swear to the counter affidavit. I have read through the affidavit in support of the plaintiff's originating summons. I admit paragraph 1 and 8 of the affidavit in support of the originating summons. I deny paragraphs 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, and 32 of the affidavit in support of the originating summons on the ground that they are not true by reason of my job as Special Assistant to President Ahmed Bola Tinubu GCFR. I know the fact and circumstances that happened in Rivers State, which culminated in the declaration of state of emergency in Rivers State by President Bola Ahmed Tinubu on 18th March 2025. It is a matter of common knowledge that there was a very serious political crisis in Rivers State, which had led to the governor of Rivers State and the House of Assembly not being able to work together. The State House of Assembly was crisis ridden, such that members of the House were divided into two, with 4 members working with the governor, while 27 members were opposed to the governor, while 1 was loyal to the Speaker of the House. As a result, the governor was not able to present any appropriation bill to the House to be passed for the governor to be able to access funds for the running of the affairs of Rivers State. Further to paragraph 10 above, by reason of the non-presentation of appropriation bill to the Rivers State House of Assembly for passage, governance has run to a standstill. The federal government accused the suspended governor of escalating crisis by demolishing the State House of Assembly. The crisis escalated to the point that the governor demolished the House of Assembly of the state, thus depriving 27 members opposed to him from having official accommodation while they could meet to carry out their duties as the House of Assembly, Oluyede said. And the governor, however, allowed 4 members he considered loyal to him to be meeting in his office. The federal government cited attacks on critical infrastructure and threats by militants in the oil-rich state as other factors behind the state of emergency. There was violence in the state. There was violence in the state with attacks on critical economic assets of the state, including vandalization of oil pipelines, with the governor not taking any steps to address the occurrences. Militants were openly threatening fire and brimstone against those that they perceived as enemies of the governor, while the governor not doing anything, even a little, as denouncing it or disowning them. Now, according to federal government, the political problem got to a stage that the governor and the lawmakers were trying to outdo one another in a series of suits on the political logjam in the state, Oluyede added. There were several suits filed by the governor and the 27 members of the House of Assembly opposed to the governor in several courts, raising counter-accusations, which each side struggling to outdo the other in the political logjam in the state. The suit eventually reached the Supreme Court and on appeal, and the court gave a composite judgment in the appeals, with the court holding, amongst others, as follows. A government cannot be said to exist without one of the 3 arms that make up the government of a state under the 1999 Constitution as amended. In this case, the head of the executive arm of the government has chosen to collapse the legislative to enable him to govern without the legislature as a despot. As it is, there is no government in Rivers State. The federal government said President Tinubu met with all warring parties, but they stuck to their guns, Oluyede said. President Bola Ahmed Tinubu intervened in the dispute between the governor and the members of the State Assembly and other political players in the state with a view to resolving issues amicably for them. But the parties stuck to their individual positions to the detriment of the peace and development in the state. Again, many well-meaning and respected Nigerians also intervened in the crisis with a view to settling it, but the governor and members of the State House of Assembly gave no room for the crisis to be resolved. Even after the delivery of Supreme Court judgment referred to above, matters still remained the same in the state, with no effort made by the parties to resolve the crisis to allow governance to resume. Therefore, to avoid further deterioration, President Ahmed Bola Tinubu had to declare state of emergency in the Rivers State to stop the drift to greater violence. The foregoing facts were captured in the address made by President Bola Ahmed Tinubu to the nation while declaring the state of emergency in Rivers State. A certified true copy of the proclamation of emergency is attached as Exhibit A, contrary to the depositions at paragraph 6, 9, 10, 11, 12, 13, 14, 15, 27, 28, 29, 30, and 31 of the plaintiffs. That's the plaintiff's affidavit. The president has neither said nor threatened that he would declare state of emergency in any of the plaintiff's states, but the plaintiffs have only been driven into panic mode by their own imaginary fears, contrary to the disposition of paragraph 18, 19, 20, 21, 22, 23, and 24 of the 4 of 9 plaintiffs' affidavit. I have read section 305 subsection 6 of the 1999 Constitution as amended, and I know that there is no stipulation therein that the resolution of 2/3 majority prescribed therein shall be by physical counting of the vote by each house of the National Assembly. The federal government insisted that the President Tinubu acted within the Constitution to declare the state of emergency in Rivers State. Oluyede said the first defendant, the Attorney General of the Federation and the Minister of Justice, Lateef Fagbemi, Senior Advocate of Nigeria, SAN, informed him in his office along Shagari Way in the central area of Abuja on 7th May 2015 at about 11 a.m. of the following fact, that which he verily believes to be true, viz., that it is the president of the country that has power under the Constitution to declare a state of emergency in the Federation or any part of it. 2, that the role given to the National Assembly by the Constitution is to approve or disapprove of state of emergency declared by the President without more. 3, that it is the President on whom the Constitution has imposed the duty to take the extraordinary measures required to restore peace and security in the area affected by the declaration of a state of emergency. 4, that he, the first defendant, as such, does not share the power to declare a state of emergency with the President, and whatever may have said to journalists does not amount to a dispute between Federation and any of the plaintiff states. Number next, that the suit filed by the plaintiff is hypothetical, academic, and speculative. That he, the first defendant, agrees with the plaintiffs that each of the governors of the 10 plaintiff states has a duty to ensure peace and security in their individual state, that the President Bola Tinubu is a strong adherent of the rule of law who has committed himself to exercising his powers and carrying out his duties as president only in accordance with the law and the Constitution and based on verifiable facts. That there was actual breakdown of public order and public safety in Rivers State before the President declared a state of emergency in Rivers State, that the situation in Rivers required the President to take extraordinary measures to restore peace and security, that even the Supreme Court, based on the facts contained in the appeals agitated to the court in Rivers State House of Assembly versus Government of Rivers State and Leper 80539, cited by the plaintiffs at paragraph 13 of the affidavit, held emphatically, among other things, that there was no government in Rivers State. The National Assembly, which was also sued on the same issue by the PDP governors, has urged the Supreme Court to dismiss the suit, responding via a preliminary objection dated 22nd of April. The National Legislature said the suit is procedurally flawed and lacks merit. It argued that the court lacks the jurisdiction to entertain the suit and should award 1 billion naira in cost against the plaintiff for filing what it termed a frivolous and speculative suit. The governors are praying the Supreme Court to determine the following: whether upon a proper construction and interpretation of the provision of sections 1 subsection 2, 5 subsection 2, 176, 180, 188, and 305 of the Constitution of the Federal Republic of Nigeria 1999, the President of the Federal Republic of Nigeria can lawfully suspend or in any manner whatsoever interfere with the offices of a governor and a deputy of any of the components of the 36 states of the Federation of Nigeria and replace same with his own unelected nominee as the sole administrator under the guise of or pursuant to a proclamation of state of emergency in any of the states of the Federation, particularly in any of the plaintiff states, whether upon a proper construction and interpretation of the provisions of section 1 sub 2, 4 sub 6, 11 sub 4 and 5, 11 sub 4 and sub 5, 90, 105 and 305 of the Constitution of the Federal Republic of Nigeria 1999, the President of the Federal Republic of Nigeria can lawfully suspend the House of Assembly of any of the component 36 states of the Federation of Nigeria under the guise of or pursuant to a proclamation of a state of emergency in any of such states, particularly in any of the plaintiff states, whether the consequent threat by the first defendant acting on behalf of the President to the states of the Federation including the plaintiff state, to the effect that the offices of the governor and the deputy governor of the states can be suspended by the president by virtue of proclamation of state of emergency, is not in contravention of the provisions of section 1 sub 2, 4 sub 6, 5 sub 2, 11 sub 2, and sub 3 of the Constitution of the Federal Republic of Nigeria 1999, and inconsistent with the principles of the constitutional federalism. Those were what drama that played out in the Supreme Court just a few hours ago. My colleague is in the house. In summary, what's your take?
Well, I think they will not really answer the questions, because the most important thing that the plaintiffs were deeming fit to know was the fact that if it is provided in the Constitution that the president have the legitimate right to suspend democratically elected officers of a state and replace them with sole administrator, they have buttressed their point on the area of emergency room, which somehow, because of the kind of government we have, it may be understood, because already this case was in the Supreme Court, and the Supreme Court brought their own verdict, which the elected officers, talking about the House of Assembly, they were trying to do for impeachment and all of that. So, and they didn't even allow it to settle. The president went forward and declared state of emergency and suspended the elected officers and all of that. So right now, it's not about beating around the bush. What is most important is it provided for in the Constitution? The president have the right to suspend a sitting governor in any circumstance, or he has the right to declare state of emergency? And they've not answered that question. That's the truth.
Okay, but let's see what the Supreme Court will eventually give us their verdict. Let's also hope that Fubara does not go ahead with political solution just yet, so that we know exactly what our democracy is heading to.